Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to have a chat about a recent decision of the Supreme Court of New South Wales that related to the conduct of a meeting and Section 249G of the Corporations Act. We have a number of different entities involved here, and they're all part of a much larger group. Today we're dealing with a sort of subgroup within the larger group, just to give you a little bit of broad background. And we've got pretty much 5 relevant parties that we're going to be dealing with today. 5, that's right. That's how you count to 5. We have our plaintiff today. Our plaintiff is a person who brings an application. So that's the person who's coming to court today who wants to have a meeting of the first defendant set. Now, the first defendant is a company, and the plaintiff wants the company to have a meeting. It's a meeting of its members, a general meeting of the shareholders. Now, defendant 2 is one of the, as a rude finger person, is one of the shareholders in defendant 1. And defendant 2 is a company, and defendant 2 owns 599 of the 600 issued shares in defendant 1. That makes sense? Defendant 1 issued 600 shares, 599 of them are owned by defendant 2. One of them is owned by defendant 3. Defendant 3 is also a company. It owns the remaining share. Now, defendant 2 is a company whose directors are the plaintiff, the person who's kicked off the proceedings, defendant 4, who is another natural person, and another person who we're not going to deal with too much. These people are siblings, but we're just going to refer to them in relation to their roles in the proceedings. So defendant 2, rude finger defendant, has the directors of plaintiff, another person, and defendant 4. And those people are the directors of that 599 share entity. Defendant 3, that's the entity that owns 1 share in defendant 1, has 2 directors. Those directors are the plaintiff and defendant 4. And at the very heart of this issue is that the plaintiff and defendant 4 do not get along. And what is at the core of the plaintiff's application is the plaintiff wants to cause a meeting of defendant 1, which you might think of as the larger company in the group, to take place, and has some proposed resolutions for what the plaintiff thinks are the right steps for that company to take. Now, the Articles of Association, the sort of governing rules of the constitution of that company, say that a meeting will not be quorate unless, there'll be no quorum unless you have at least 2 of the shareholders present. Now remember that defendant 1 has only 2 shareholders. Those shareholders are defendant 2 and defendant 3. Do you remember who controls defendant 3? Rude finger defendant, sorry, I'll draw that. Defendant 2. Do you remember who controls defendant 2? Well, that's the plaintiff, another person, and defendant 4. The plaintiff and the other person are comfortable with causing defendant 2 to vote in favour of what the plaintiff wants to do. Now, defendant 3, that owns 1 share in defendant 1, has the directors of the plaintiff and defendant 4. And as you might remember, the plaintiff and defendant 4 do not get along about this meeting. And so what happens is, because defendant 1 can only hold a meeting in accordance with its Articles of Association if at least 2 shareholders are present, well, only 1 shareholder is going to show up to that meeting, the rude finger shareholder, because the other shareholder is not prepared to go ahead with that meeting. And so we come to the plaintiff's application before the court today. Pursuant to Section 249G of the Corporations Act, what the plaintiff is trying to do is try to cause this meeting of defendant 1 to go ahead and to appoint a representative of defendant 3 to go ahead and attend that meeting in order for it to proceed. Now, the defendant 4 continues to resist. And what defendant 4 says, in short, is, hey, there's another piece of litigation that is relevant to these disputes, and I'm not going to cause defendant 3 to assist with this plan to conduct this meeting until the Court of Appeal hands down its judgment on this point that I say is relevant to determination of what's going on here. I need to hear from the Court of Appeal before I agree to cause defendant 1 to meet to consider these proposed resolutions. Now, the very short point of that is that as this litigation rolls forward, the parties come to understand and come to agree between themselves that the Court of Appeal decision is going to be of no moment, of no real sort of relevance to determining whether the plaintiff's meeting application should go ahead. And so we turn to consider what the plaintiff has to convince the court of. If you're going to move the court to give you relief pursuant to section 249G in relation to calling a meeting, firstly, you've got to show that it's impracticable to cause the company to meet in any other way. And secondly, you have to move the court to exercise its discretion. So it's up to the court to exercise its discretion whether it's going to give you these orders or not. So point one was a fairly quick tick for the plaintiff, because with this sort of deadlock surrounding defendant 3, the court was able to say, yes, it is impracticable for this meeting to go ahead, and so we need to think about whether we're going to exercise our discretion, right? So step one, yep, there's a deadlock, it's impracticable, so let's move to step 2 and think about whether we're going to exercise our discretion. The court does indeed exercise its discretion, and it does for a number of reasons. Firstly, the court finds that the Court of Appeal decision is essentially sort of irrelevant to any consideration of whether or not a meeting should be held or not, so the Court of Appeal issues can fall away. Another issue is that the court needs to deal with the current state of affairs before it, and not the kind of theoretical state of affairs that defendant 4 is talking about of, oh, things will look different when we have the judgment from the Court of Appeal. And so the court's view is, look, that may or may not be right, but frankly, we're being asked to make orders about the position we're confronted with now, so this future hypothetical scenario is not one that's strictly relevant to us now. Thirdly, there's the position that the fourth defendant might just change their view. So if the plaintiff doesn't get the orders it's after, and the defendant says, oh yeah, no, I'm going to cause defendant 3 to meet to defendant 3 to meet after this, and we're going to sit down and discuss it, don't worry about it. Well, there'll be no orders actually binding defendant 4 to do that unless the plaintiff gets the orders they are after. And so the court says, well, defendant 4 might just change their position, and so there's no real way to stop that. And then the fourth reason for the court not exercising its discretion was that there are other sorts of applications that could be brought by defendant 4 or related entities to defendant 4, things like corporate oppression, things like an application for an interlocutory injunction that had already been considered and indeed proceedings commenced but not served on the other parties. So the court said there are these other curial processes that you can make use of to assert your position, and the fact you have elected not to do that means that we're going to lean in favour, or it's going to be one of the factors that lead us to lean in favour of exercising our discretion in favour of granting the relief the plaintiff's after. And so, because the plaintiff has shown, bing, it is impracticable for this meeting to go ahead because defendant 1, remember, can't meet without 2 shareholders being there, and defendant 4 is stopping one of the shareholders from attending the meeting. So impracticability test is met. So the court, having considered those 4 factors, elected not to exercise its discretion against the plaintiff and elected to exercise its discretion in favour of the application brought by the plaintiff. I hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.